All rise.
Thank you. Please be seated. Mr. This is CV-2022-01468 in the matter of Gene Kench and Ted Boyd and Abram Hamadeh versus KRIS MAYES, Katie Hobbs, etc. Defendant. Show the presence on the video Zoom of Mr. Lesotho representing the plaintiffs in this matter. Show the presence of, I see Mr. LaRue and Ms. Dool representing Maricopa County. Do I have anybody here for I see Mr. Moore from Navajo County. Who do I have for Secretary of State Hobbs today?
Your Honor, Mr. LaRue and I are in the same room because we're here at the court for the Lake trial and stepped out for this. But Bo Dool here on behalf of the Arizona Secretary of State.
All right, thank you, Ms. Dool. And then who do I have on May's behalf?
Your Honor, this is Alexis Daneman, and I have with me Dan Barr and Matthew Kerner.
All right, and so the presence of Ms. Daneman. Are you going to be doing the speaking today then, Ms. Daneman?
Yes, Your Honor.
All right, this is kind of an emergency hearing set. I recognize other people are still in a courtroom or outside of a courtroom. There's a hearing going on today related to similar issues, although not the same, I don't believe, but a different party had brought a case. But some of the defendants are in that case, and the representation is there at the courthouse and participating in that case. So I understand this hearing was set on short notice. I get a request for this hearing from Mr. Lesotho yesterday based on his inability or their inability, the party's inability to come to any agreement on inspection of the ballots. The court had kind of hoped that that would not be the case, but that's what was received. I have reviewed Mr. Lesotho's pleading that was filed yesterday. I believe it's titled a request. It was titled as a request for a hearing. Response to the court's order requiring written submissions regarding issues on which no agreements have been reached. I did also receive notice regarding the inspection of ballots from the Maricopa County defendants, and I did receive something from the Mayes defendants as well. I also received something from Navajo County from Mr. Moore, filed something on, because Mr. Lesotho had requested, and I did get the Navajo County. I did order that there could be an inspection of their ballots as well. But then there's also Pima County has filed a motion to dismiss, and they said they weren't even here at the previous hearing, and so they're not subject to some of the things. We'll discuss all that as quickly as we can this morning on these details. This is an interesting issue. This is the ballot. I have it up 16677. The ballot inspection statute is pretty short, pretty easy to read, but everybody's taken different interpretations of it. Mr. Lesotho, you could not reach an agreement. I guess I'd hoped, even if you hadn't reached an agreement, what you did agree on, that you could get some ballot inspection done prior to today, but I'm not sure that ever happened. So, Mr. Lesotho, what is it you want to put on the record today?
Well, Your Honor, and I do have Secretary of State Ken Bennett. Hopefully you saw his declaration, but he's prepared to testify consistent with his declaration that the CVR is critically necessary to inspect the ballots, and as he puts it, if you want, we can hear from him. But
I've read his
okay.
What was attached to your document. I read it completely. I saw that he signed it. It is under oath, and I'll just accept it as his testimony.
Okay.
I don't believe.
So I mean, our position is that the inspection of ballots is sort of void of real meaning absent the CVR, and there's no real there's no reason not to turn over the CVR. We'd also asked for the provisional ballot list for Maricopa County. I have no idea why they won't just provide that. They're sticking to this position that that's discovery, and that's not allowed. I mean, it's obviously a public record. I for the life of me, I do not know why they can't provide that. What I would suggest, Your Honor, is that, well, if you are inclined to give us the relief we've asked, is that we push the hearing to Tuesday. I think also in there, you probably saw that the recount hearing has been reset for Thursday of next week. So I think we have a little bit more time than we had previously anticipated. But I think that's essentially what we should do. And we should tomorrow and maybe over the rest of today, we should try to get to the work of inspecting the ballots, which necessarily involves the CVR. I mean, we've got an expert who has said that, and I think when the statute was written, you didn't have things like CVRs. You just had paper ballots. I think it's necessarily implicit in inspection of the ballots, as Mr. Bennett attested to. I know that there's the question of who's responsible for the fact that we have not had the inspection. I mean, I think we've worked in good faith. We agreed to the round of briefing on the motion to dismiss. I think sort of every place we turn, we've got every governmental body involved that's making a presentation here, kind of trying to block us, limit us, well, whatever you want to call it. It's just we haven't gotten what we think is the cooperation that the court's order kind of assumed would happen, and the CVR is at the heart of that. So with that, Your Honor, I'm happy to answer any questions.
Do you agree that when I read your original petition for inspection of ballots, the CVR is not even in it?
Well, Your Honor, we did put the CVR in a subsequent briefing to the court, that we have to have the CVR in order to really make heads or tails of the ballots. So, I mean, it's something that I think is just sort of part of the ballot inspection process, because it's, as Mr. Bennett says, it's sort of the tally of the ballots. So, I mean, I think it is sort of, it's part and parcel of that.
Ms. Danneman, you want to be heard?
Sure, Your Honor. I mean, I'd like to start with the cast vote record. The statutes make clear about what the plaintiffs are entitled to, and that's one thing, that's the inspection of ballots. There's nothing else under ARS 16677 or any other provision of the election contest. And there's a reason for that. These sorts of proceedings are meant to move quickly. And, I would submit that it doesn't matter what the declarant or Mr. Lasota thinks is necessary to inspect ballots. The legislature has already made a choice about whether the CVR can be inspected, and they made that choice in ARS 16625, which provides that election officials shall ensure that electronic data from electronic or digital ballots are protected from physical and electronic access. That's the data here. Plaintiffs admit that, their declarant admits that, noting that at page 4 of their brief, information in the CVR directly correlates row by row with the ballot images. So we don't have to guess about what the legislature wanted in this case. They have made clear what's permitted in election contests. That's a very narrow thing, the inspection of ballots, and that makes sense given the extremely accelerated time frame here, as Your Honor well knows from handling many of these cases over the year. And then they've gone on to expressly prohibit this exact thing. The other thing I'd like to touch on, just in response to Mr. Lasota, is the idea that we could continue this hearing. We absolutely cannot. ARS 16676A provides that the court shall set a time for the hearing of the contest not later than 10 days after the date on which the statement of contest was filed. And then if there's good cause, which Your Honor, we've submitted and we will submit again, there has not been in this case, that the hearing can be extended for 5 days. And so in that case, they filed their petition on the 9th, 15 days, which is a very out of bounds of what this court is permitted to the time period in which this court is permitted to conduct the hearing, is going to be Saturday, December 24th. And then, the last point I'd like to hit on is the idea that Mr. Lasota floated that this is somehow not his fault that we're in this position. This petition was filed on the very last day that he was permitted to file the petition at 5 p.m. He didn't file, that was the 9th. He didn't file the petition to inspect ballots, which he apparently knew was a key part of his case until multiple days later. And then yesterday, when Maricopa County was willing to work with them immediately, he spent the day writing this brief. So the idea that this is not plaintiff's fault that we're in this position, KRIS MAYES strongly disagrees with that in this case, Your Honor, and there's no authority to move this hearing further.
You would agree if the hearing was scheduled, the last day was the 24th, and that's a Christmas Eve, a Saturday. My next court day would be Tuesday, the 27th. That would be allowable under the rules. You would agree with that, wouldn't you?
I do not, Your Honor. That relies on that reading would rely on Rule 6A, which does not apply in election contests. Election contests are accelerated matter. Timeliness is of the essence. 10 days means 10 days. There's no authority for this court to extend the hearing.
Right. If I were to order some sort of inspection of ballots today, to be done today, that would be able to get done?
Your Honor, may I be heard on that? This is Joe with Maricopa County.
I'm asking Ms. Daneman right now, but I'll come to you, Mr. LaRue. You'll have your chance.
My apologies, Your Honor.
Your Honor, Ms. Mays submitted her name of the one person to submit to inspect ballots 2 days ago. And I think and we are ready to go. We've been ready to inspect ballots, but I think this raises the other point that Mr. Lasota made at his briefing, which is somehow this court has the authority to appoint 15 people on behalf of the plaintiffs to inspect ballots. And then I guess 45 people total to go across the state and inspect ballots. That is simply contrary to the plain text of the statute. Which says that the court shall appoint 3 persons. It then explains how these people are selected. One is selected by each of the parties and one is selected by the court. This 3-person team is the team that is supposed to select ballots. And this makes sense. It's supposed to be a unified looking in preparation for trial. This is not a discovery hunting expedition for new facts. This is a trial preparation mechanism. The statute contemplates a board of 3 people, a unified board of 3 people. And the idea that the legislature intended for courts to appoint some limitless number of 3-person boards to conduct an extensive statewide inspection of ballots just makes little sense in the context of an election contest case. Again, these cases are highly accelerated, and that this limited mechanism is meant for preparation for trial, not for some wide fact gathering expedition. So I would say that the court has only the authority to appoint 1 board. Ms. Mays has nominated her person for that board. We are ready to go. So to wind back to Your Honor's question, yes, we are ready to inspect ballots today if that is what the court orders, but it cannot proceed in the manner that the plaintiffs have suggested in this case, which would be not only chaotic, but against the plain text of the statute. And to my knowledge, and I will let the government officials on the phone speak to this more clearly, but I am not aware of any case in which this court has appointed more than 1 board to inspect ballots.
Thank you, Ms. Daneman. Mr. LaRue.
Thank you, Your Honor. With regard to Maricopa County, it would not be possible to conduct a ballot inspection today. Mr. Scott Jarrett, who is our elections director, who oversees tabulation and is now, as the representative of the Board of Supervisors, the custodian of the ballots. He's also the one who is really the one who's knowledgeable to be able to find the ballots, to conduct the inspection. Mr. Jarrett is under a court subpoena and will be testifying today in court in the Lake v. Hobbs matter. So he's not available, and we let Mr. Lasota know that, I believe on Monday, that Mr. Jarrett would only be available on Wednesday, and that's why we offered to do the inspection on Wednesday. I'd like to be heard on the other things that Mr. Lasota argued, but if now's not the appropriate time, that's fine, Your Honor.
Now is the appropriate time. Go ahead.
Thank you, Your Honor. I want to talk about the cast vote record. That's kind of gobbledygook to most people. It certainly was to me until I got, neck deep in Maricopa County elections. But the cast vote record contains a record of every action that a tabulator machine takes on each ballot that passes through it. So it will actually reveal what votes were cast on each individual ballot. With the cast vote record, one has the entire election and one knows the results. So if Mr. Lasota is seeking the cast, and it's unclear to me at this point what exactly Mr. Lasota is seeking, but I want to deal with the two possibilities. If he's seeking the cast vote record from the recount, Maricopa County by law cannot give that to him because the cast vote record from the recount would reveal the results of the recount. And the statute says that the court is to announce the results of the recount. Nobody's supposed to know about it in advance. And we have a court order down here in Maricopa County saying the same thing in the recount contest. So, or the order that authorized the recount, that ordered the recount. So we cannot turn over the CVR from the recount. If Mr. Lasota is seeking the CVR from the general election, there are also problems with turning over an unredacted version of that CVR. There was a study done this past summer, I believe, by a group of professors who identified a security flaw in the cast vote recount. And our IT people have confirmed that flaw. It's a remote possibility. I want to acknowledge that for the court. But there is a possibility that someone with technical expertise and with the right pieces of information could reverse engineer the CVR and the data in the CVR to identify particular voters and their ballots and determine how I voted or you voted, Your Honor, if you were in Maricopa County, and tie it to our names. And that would violate the secrecy clause of the Constitution. And that's why Maricopa County, even though we take a different view than some of the other counties, we do believe that the CVR is a public record subject to production. We don't believe it's a protected ballot pursuant to 16625. Some of the counties take that position, and it's a reasonable position. We don't take that. But even though we don't take that, and we do produce the CVR, we always redact now the portion that has been identified that could allow somebody to reverse engineer how a particular person votes. I also want to point out, Your Honor, that Mr. Lasota in his argument said, and I'm quoting here what he said, when the statute was written, you did not have the CVR. And that right there, Your Honor, it seems to me is an admission that the legislature did not intend for the CVR to be part of this very limited discovery of the inspection of ballots. The legislature said the ballots, and that's what they said, that's what they meant. You did not have the CVR, so what they wrote must have meant something. It can't be the case that ballot inspections only became meaningful once we had the CVR. Because the CVR is only a product of certain tabulation machines in the modern era. The second thing that I want to highlight, Your Honor, is that Mr. Lasota said the CVR is the tally of the ballots. I would phrase it differently, and I did for the court. I said it's a record of the actions the tabulator takes, but Mr. Lasota's description is not incorrect. We would just phrase it differently. But either way, tally of the ballots, record of the actions the tabulator took, the CVR is not the ballots, and the statute authorizes inspection of the ballots. With regard to the list of provisional voters, once again, Your Honor, I want to point out they are not the ballots. They're not authorized by statute. Mr. Lasota has argued in his papers that these are important, and they may be. I don't want to dispute that with Mr. Lasota, but many things are important in election contests. And if the court opens the door to discovery of important things, it will first off violate what the legislature wrote. Second, it will make election contests impossible from just an administrative standpoint to get everything done within the statutory period that the legislature has allowed the parties and the court to conduct an election contest. Your Honor, the final thing that I would like to say is I do believe Mr. Lasota has acted in good faith. He said the parties have. I completely agree. Election contests are hard. They are compressed. There's not enough time. But that's a question for the legislature. If people want to change the election contest rules, which perhaps they should be, that's something for the legislature to take up. It's not for the court to do. And while Mr. Lasota has acted in good faith, and Maricopa County has certainly acted, Mr. Lasota did not accept the one offer that we could have done that would have provided him inspection of the ballots. We were ready to go at 9 a.m. yesterday morning, just in case Mr. Lasota decided he wanted to do this. And Mr. Lasota did not. And so now it's simply too late. The clock has run, and there's not really an option to conduct this. And with that, Your Honor, I'll be happy to answer any questions.
Do you agree with Ms. Danneman that if I ordered it tomorrow when Mr. Jarrett is not in court, that next Tuesday is too late for the hearing?
I do, Your Honor. I believe that this is a statutory rule, the 10 days. I believe that it's subject to strict compliance. And I don't see any authority to extend it beyond the 10 days. And I want to point out, Your Honor, the county doesn't really have a dog in this fight other than to defend the integrity of our election. We're not on either candidate's side, but we do need to abide by the law. And, you know, my view of the law is Tuesday would be too late, Your Honor. One thing that I meant to tell Your Honor, and I forgot, I apologize, but to go back to my argument for just a moment, I want Your Honor to know that another impractical or difficulty that the county would face, it would be impossible for the county to comply with, would be any type of inspection team beyond the 3-person team contemplated by statute. All of the ballots right now are sitting in our ballot tabulation center. That's where the inspection would need to be conducted under the cameras so that everything is viewable by the public, because we're handling live ballots. Currently, there is not room for 24 people plus attorneys in the ballot tabulation center. We just conducted an inspection in the Lake v. Hobbs matter. There were 3 inspectors. There were the elections department staff to go find and retrieve ballots and assist with the inspection. There were a handful of attorneys, one for the plaintiffs. The secretary did not send an attorney. There wasn't even one, now that I think about it, for the governor-elect present. And with that, we were shoulder to shoulder in the BTC. There simply is not the room for the type of inspection that Mr. Lasota is contemplating, even if the statute did allow it. And with that, Your Honor, I'll stop.
All right, thank you. Is there somebody from the Secretary of State?
Yes, Your Honor. Bo Dole here for the Secretary of State. May I be heard?
Yes.
Your Honor, just a couple quick additional points. The Secretary agrees with the points raised by the Maricopa County defendants as well as KRIS MAYES. But on the cast vote record issue, I'll add and point out, Your Honor, that the Arizona Republican Party was before you just 6 months ago, claiming that Arizona's early voting regime doesn't adequately protect the secrecy of ballots and therefore violated the Arizona Constitution's protection for a secret ballot. This court soundly ruled against them then, yet now its nominee for Attorney General is asking this court to compel Maricopa County to hand over information, namely the cast vote record unredacted, that could be used to trace an individual voter to an individual ballot and therefore violate the Constitution's protection for a secret ballot. The Secretary has an obligation to protect voters and to protect voter secrecy, as all election officials do here in Arizona, and the court should reject this dangerous invitation from the plaintiffs in this case. The secretary also joins the other defendants, Your Honor, in objecting to the plaintiff's request to have the court appoint multiple boards, 4 to 5 people for ballot inspection. That's simply not what the plain text of 16677 allows. Plaintiff's proposed statewide fishing expedition is not only contrary to the statute, it is unworkable and extremely burdensome for election officials, not only in Maricopa County, but in the other target counties. The secretary also objects to this position from the plaintiffs because it would basically turn 16677 into a backdoor to an unauthorized recount of ballots, working an end run around Arizona's very clear and very specific rules about when a recount can occur. And that recount is occurring as we speak as to the races, including this one that actually meets the statutory criteria. Plaintiffs can't conduct their own recount parallel to that. If the plaintiff's position were correct and the statute's 3-person limit for the inspection board means nothing, then there is no limit, Your Honor, and the plaintiff could ask this court to appoint 3,000 or 30,000 inspectors to be deployed across the state to inspect and to recount the ballots cast. That's simply not what the statute contemplates. It's incompatible with the contest statute that contemplates that plaintiffs would file a verified statement of election contest that's based on actual evidence that they have in hand. It's not compatible with the contest statute, which contemplates expedited proceedings and prompt resolution of contests so that the will of the people can be effectuated and the elected officials can take office. The plaintiffs argue, Your Honor, that if the court doesn't allow them to do what they want, which would ultimately drag out this proceeding, which is supposed to be expedited so they can inspect some untold number of ballots for some untold number of days with the cast vote record, then what's the point of ballot inspection? Your Honor, with all due respect, the fact that the plaintiffs have no evidence to prove their claim without this kind of widespread ballot inspection that's beyond the scope of the statute is not the defendant's problem. It's not the secretary's or the county's problem. It's not the court's problem. It's the plaintiff's problem. And it only goes to show that this case never should have been brought. The secretary's interest here is in finality, and she strongly urges the court to take into account the strong public policy favoring the finality of the election results. And that, coupled with the fact that we must make all reasonable presumptions in favor of the validity of the election, means that there can be and should be no further delay. If any ballot inspection is to be had, it should be had today. The court should proceed with the trial that it set a week ago and quickly render its decision. Thank you, Your Honor.
All right, thank you. I guess before I go to anybody else, what I heard from Mr. Lasota during the argument the other day was a request to inspect Maricopa, Pima, and Navajo, in my mind contemplating 3 separate 3-person boards, not 45 people, 9 people, and doing it as 3-person boards. That's the way I read his request, and not a request. And then, of course, I did see the attachment to one of the pleadings, and it might have been his pleading, but it had multiple names of persons on it that he wanted to do participate in this process. As I read, and I'm going to hear from Mr. Moore here in a moment, as I read 16677, it contemplates allowing inspection of ballots and discovery, but it limits in a very definable way the scope of that discovery, and it limits what can be done. It doesn't mention this CRV in any way. So I'm going to hear again from you, Mr. Lasota, but I see that as a limiting, both an opportunity to do discovery, but limiting in the scope of what can be done as well. And it's because of the nature of these challenges, when they have to be heard. Even if I did a hearing next Tuesday, that's expedited. That's not how trials work in normal process. This process is expedited beyond belief. And then when you hear, for example, that there's other hearings going on, specifically some of the defendants in my case are in court today dealing with this, with the similar but not the same issues, and that makes it even more difficult for them to participate in this process. So Mr. Moore, you filed a document yesterday, and it kind of had some interesting stuff in it. If you want to tell me your position on inspection of Navajo County ballot. So Mr. Moore is from Navajo County.
Yes, Your Honor. Thank you very much. Good morning. I filed a response yesterday. I wasn't exactly sure what to call it. It was really a response to Mr. Lasota's response, but at any rate, a couple of things caught my eye immediately when that was filed. One is that Mr. Lasota is asking for the court to appoint the person who has custody of the ballots to be the court's appointed inspector in this matter. I don't think that's appropriate for any party that's a party to this case to be appointed the inspector of the ballots. And I think it especially creates a problem when Mr. Hamada has alleged in paragraph number 52 of his complaint that Navajo County did not set up its machines properly, or that they were malfunctioning. That is something that my elections director, Raylene Richards, who's on the line here today with me, would adamantly defend against. Our voting equipment passed logic and accuracy test by the Secretary of State's office before the election. It passed the internal logic and accuracy test after the election. It counted the votes correctly and operated exactly as the way it should have. And, you know, as Mr. LaRue said, we're not here to, take sides between candidate Hamada and candidate Mayes. That's not the point at all. The point is that we're here to defend the accuracy of the canvas that we submitted to the Secretary of State's office, and which was in turn approved by on a statewide basis. And so that's one problem. The second problem, Your Honor, is this: under the regime that Mr. Lasota has put together, he wants, apparently candidate Hamada and candidate Mayes to be able to appoint 15 different inspectors on their own, and then the person in charge of the person who has custody of the ballots, which technically, by the way, at this point should be the treasurer under the statute if you read it. But even if you want to say that, well, that's the election director, what it does is, okay, we're going to have a situation here in Navajo County where he suggested that we have 4 representatives of Hamada, 4 representatives of Mayes, and then apparently he thinks either the county treasurer or Ms. Richards is supposed to be the third person of each of those teams. And Ms. Richards is only one person, and she cannot be looking at the same ballots that the other 4 teams are looking at all at the same time. This statute, when it was written, it may not have been designed in a way to allow for a deep and meaningful inspection of ballots. But this is the legislature, the statute the legislature put together. It said very specifically that the court has the authority to appoint 3 people, and 3 means 3. It doesn't mean 9. It doesn't mean 45. And when a statute is this specific, I think that, unless the court is really into judicially rewriting this thing to meet the needs of the real parties in interest in this case, I think you're stuck with 3 people, and that may not. And you can have a policy debate, all day or not, whether what the legislature put together is an effective way to conduct these types of proceedings, and whether that's a sufficient inspection. But even at the time the legislature wrote this, when you think about the fact that, you originally had 15 parties to the case, and, the plaintiffs have reduced the scope of that to 3 counties, but when the statute was written, it contemplated an inspection theoretically of all the ballots in the state and all 15 counties. That would have been a Herculean job. It's even a Herculean job just to do it as to 3 counties, especially on the compressed timeframes we have. But that's what the legislature gave us. And that's what the court has to work with. And so, I think that that's pretty much what we're stuck on. I can't have, my elections director supervising 4 different teams. And I would point out at the same time, the same statute says she is the one that's supposed to be functionally being the ringleader and coordinating all of this. She has a lot of other jobs to do while this inspection is going on. And that includes identifying the specific ballots that the plaintiffs want, being able to pull those out. She has a lot of other responsibilities in this thing. And so, I did suggest to the court, that the court appoint a specific individual, Lynn Constable, who was the former elections director in Yavapai County, to be the court's appointed inspector for all 3 counties that plaintiffs are now asking. There has been some contact with Lynn. It's my understanding that her availability, it would depend on the timing of when it needed to occur. And this is something that I communicated to Mr. Lesota right off the bat as soon as the court issued its order on Tuesday. I immediately said, number one, you have a problem because we don't have even if, you and Ms. Mayes representatives appoint, your individuals right away, we still don't have a representative from the court, and we can't start this process without a court representative. And then number 2, I said, we're on an extremely compressed time frame. You have to identify the specific ballots that you want us to pull for you. And we need time to try to identify those and get them pulled. And then, number 3, I think that if you're going to go forward, with this inspection, that we need to have good and clear communication between the members of the inspection team. And so I gave him the email address of Ms. Richards, as well as my county recorder, Mike Sample. And I said, when you guys have your inspectors, and the court has appointed an inspector, and I urged him to take immediate action on that, I said, have those inspectors get in touch with my people immediately so that they can coordinate schedules, because that's going to be a big issue. And coordination of schedules is going to be hard when you're talking about, 3 inspectors plus, a county elections official, at least 1 county elections official, and there's probably going to have to be more than 1. But, when you start trying to coordinate schedules between, 9 or 45 or however many, the process is going to get that much more complicated. Your Honor, the statute says what it says. It may or may not give the plaintiffs the relief they want, but it's what we've got to deal with. And so I'll be happy to answer any questions you have.
The only question I have, your county has the ballots from Navajo County? You have the Navajo County ballots?
Oh, yes.
All right. That's the question that I thought was accurate, but I just wanted to contemplate for the record. Is there somebody from Pima County on the line?
Morning, Your Honor. Daniel Jerkowitz on behalf of Pima County defendants, and with me today is the Deputy Elections Director, Jeremy George.
All right. First of all, could you spell your last name?
Yes, Your Honor. It's Jurkowitz.
Jurkowitz.
Correct.
And can you get on Zoom video, or are you just on audio?
I'm on.
Now I see you now. I'm sorry. You're up in the Peter Brady spot up on the top. All right. Mr. Jerkowitz, obviously your county filed a motion to dismiss. You're one of the 3 counties that I had contemplated doing a ballot inspection after Mr. Lesota only requested those 3 counties, including Pima County. You believe, or at least if I'm reading your document right, that you filed a motion to dismiss based on not getting into this case early enough. We've already done the arguments on the motion to dismiss. I've made my rulings on that. One of the things that's clear to me, and you brought this up again in your motion, is laches just does not apply to them filing this on the fourth or fifth day after the canvassing of the elections. That is within the statutory time periods. The only case, the Lubin case, I think it is, that even contemplates finding somebody that filed something in a timely manner to be, you can't go forward because of laches, was because that particular party didn't pursue the case after it got filed, not because of the timeliness of the filing. So I don't believe that laches applies to them, not to the timeliness of the filing. So if you want to make other arguments this morning about why Pima County should be dismissed, you can do that, but there is no argument on the laches issue from that perspective. If you
Respectfully, Your Honor, my laches argument was the fact that plaintiffs served Pima County yesterday afternoon. Trial is tomorrow. We've not had any opportunity to participate in this matter or prepare. There are allegations of misconduct against my clients, and we would have to defend those tomorrow. We are incredibly prejudiced by that. The plaintiffs here did not take the necessary steps to pursue this matter in an expeditious fashion, and it is perfectly appropriate for Pima County defendants to be dismissed because of their inaction, their dilatory conduct here. So obviously that's within the discretion of the court, but we would object to this going forward. We are severely prejudiced by this matter. There's no reason whatsoever why Pima County defendants were not served earlier in this process. And if the court orders that we have ballot inspection today, we'll be prepared to go forward with that to the best of our ability. But we're in a really difficult place because we just got brought into this case a couple of hours ago.
Right. Thank you. Mr. Lasso, do you want to address that?
Yes, Your Honor. So we corresponded with Mr. Jerkowitz last week. Actually, it was Mr. Willencheck who spearheaded that. I thought Pima County had accepted service. Turns out they made such acceptance contingent upon getting 60 days to respond to the complaint. So, I mean, that's what happened there. But I think the bottom line is, they're not the contestee. They were sent all the documents last week, and we got this business about, well, yeah, we'll accept service, but we want 60 days. They didn't want to be in the lawsuit. And I certainly, I mean, who wants to be a defendant, but they're really in it as a, well, I mean, they're in it like the other counties are in it, and ballots are, we want to inspect the ballots. But you heard Mr. Jerkowitz, he can be ready for he can be ready for a ballot inspection. So I think that the arguments have essentially been made and rejected already by this court as to that we shouldn't have a ballot inspection at all. So, I mean, there's obviously a lot more to the service story, but I think that the arguments that he's made have been rejected, and he just said they'll be ready as best they can for a ballot inspection.
All right, so you've heard, you've now heard from the other side. How are we doing this? I guess you want this CRV, but if you're not getting the CRV, how are you proposing to do inspection of ballots, especially when Maricopa County person that would be in charge of that isn't even available?
Well, Your Honor, in terms of the argument that we can't have this hearing on Tuesday is just, I mean, it's not even close to being correct, and I can tell you why. Because 16-676 basically says you'll start the hearing. Well, we've already started a hearing already. The other important thing is Your Honor points out, the 24th is Saturday, and I'm going to quote from Burke v. Ducey in 2021. Notwithstanding the fact that the election contest statutes do not include intermediate Saturdays, Sundays, and legal holidays, the court will continue to adhere to the rule that if the fifth day for filing an election appeal falls on a Saturday, Sunday, or state holiday, a notice of appeal will be deemed timely if filed on the next business day. So why would that not also be the case with when the hearing has to start? And the last thing on that matter is Brousseau, which is a report. Now that Burke v. Ducey that I just quoted is unreported, but it is an Arizona Supreme Court decision from 2021. Brousseau says not holding the hearing on within the 15th day does not deprive the court of jurisdiction. Now, you know, the court in Brousseau did say that you know, kind of faulted the trial court for just not doing it. I mean, here there's no fault on the part of the trial court, and there's no deprivation of jurisdiction. So, I mean, we could have this hearing Tuesday. We could use tomorrow to inspect the ballots. I mean, a lot's been said. What we were suggesting, we didn't want multiple panels in all the counties. I think Maricopa County has had multiple panels in the past. That's my understanding. I don't view the statute so narrowly, but look, I mean, Mr. Moore, for example, his suggested appointee for the court in Navajo County is certainly fine with us. And you could take the first person on our list, and that can be our appointee in Navajo County. So, I mean, a lot's been said in terms of and you know, there's a lot of other things. It wasn't filed on the last day. I have no idea why the other side keeps saying that. It's not true because of Burke v. Ducey. As I just said, the last day would have been Saturday to file this election contest. But actually, Burke v. Ducey tells you it's actually Monday. So, I mean, there's obviously a very, and I think Mr. LaRue kind of, I think there's a big concern here with precedent, but I think the bottom line is, and that, well, you know, if you do this now, then everybody's going to do it. I mean, we have a 511 vote margin. I mean, that, you know, it's very narrow. I don't think we have a lot of worries about precedent in this case, because this is, as far as we know, it's the closest by percentage statewide election in Arizona history. So small errors can make a big difference. So, I mean, that's what we would say. We do want the CVR. I mean, we will proceed regardless, but, you know, but I will just say, you know, the people who I rely on, who are experts, you know, they tell me that the inspection just is much more difficult without the CVR. And I also think this business about reverse engineering is not accurate. You saw in the declaration that this has been declared a public record in another state. We think if you have an extremely limited number of people at a precinct, then it could be a situation where you could reverse engineer it, but we think that's completely unrealistic. And with that, we would ask for the CVR. If we don't get it, we will try to proceed. My experts have told me that is extraordinarily difficult, but we'll proceed with what we have before us, Your Honor.
Your Honor, this is Ms. Danman. May I be heard on behalf of Ms. Mayes?
Yeah, as long as Mr. Lasota gets the final word. Go ahead.
Sure. I mean, I'd like to address first this point he made about Burke v. Ducey and the extension of the deadline. Burke v. Ducey is not a precedential order of the court, and the court said this in passing in dicta, relying on dicta in another case that is contrary to numerous published opinions that say 6A doesn't apply in election cases, and it would be contrary to the general principles in election cases about time being of the essence, and it is here, and Your Honor, unfortunately, is well aware of that. I would also like to discuss Brousseau, which Mr. Lasota referenced. It would be error for this court to extend the deadline for this matter beyond the 15-day period, which we already think is too far. A question of whether it would deprive the court of jurisdiction or whether it would just be an error if it was prejudicial. It doesn't matter in this case. It would be prejudicial. Either way, Brousseau does not allow this court to extend the hearing beyond tomorrow. And then the last, substantive point is the idea that we can appoint different boards in different counties. I don't want to belabor this point, but it is contrary to the text of the statute. The legislature has had this for a long time. They haven't amended it, and all of the difficulties that the parties have been discussing regarding this procedure really highlight why this is such a problem. The The statute says not more than 3 people, and this makes sense if you're using the statute as you must to prepare for trial, not to gather evidence. If you have whatever number of counties and whatever number of people, are all of them going to testify in the hearing about the evidence that they gathered? That's not how this is supposed to work. There's supposed to be a unified unit, one board, as Mr. Moore said, looking at the ballots and preparing for trial. And I just want to be clear about, what's happening here, which is that the plaintiffs filed a lawsuit without any facts, and they still don't have any facts, now I think less than 24 hours from the date that this has been set for a hearing. We strongly object to pushing this out further or the appointment of multiple boards, which violates the plain text of ARS 16677. And, I think that and the reason we're in this position is because of plaintiffs' delay.
Hawes, you're standing up for some reason?
Your Honor, and I apologize for interjecting, but I wanted to get Mohave County's perspective out before Mr. Lesota has his final say. But the court did in its order Mohave County to suggest or make a suggestion as to who the court's appointed inspector should be. Mohave County has done that. We have reached out to Christina Estes-Werther from Pierce Coleman, and I can give the court a phone number for her. She's the former elections director for the Secretary of State when Mr. Bennett was the Secretary of State. We have reached out to her. She has agreed that if appointed, she would take care of her duties as the court's appointed inspector. And we've also spoken with Maricopa County about that. And they indicated to us that they had no issue with that. As Mr. LaRue said, I don't think they really have a real dog in the fight. They're not on either side of for either candidate, and nor is Mohave County. But Mohave County also does have an interest in getting this resolved, Your Honor. And the CVR arguments are clear. The statute doesn't contemplate inspection of the CVR. And in fact, 16-625, what hasn't been mentioned is that the second part of that one sentence statute says that that the digital images of the ballots and the electronic data from it are to be protected from physical and electronic access, including unauthorized copying or transfer, and that all security measures are at least as protective as those prescribed for paper ballots. And therefore, the CVR has to be kept in the custody of the county treasurer under 16-624. We would disagree with some of the arguments that have been made by some of the counties. It is not a public record. The statute is clear that it is not a public record, and it has to be guarded in that fashion. And in fact, the inspection statute 677 does not allow for that for inspection of the CVR. But what Mr. Lesotho has asked for is for the counties, or some of the counties, to provide copies of the CVR to him. That's specifically not allowed under the statute. And there's no question about that. The plain language of the statute is clear. Furthermore, with respect to, we would agree with the candidate Mayes's arguments as to the timeliness. This needs to be, the timelines are what the timelines are, and it needs to be resolved. Mohave County has a concerted interest in having this resolved as swiftly as possible. And furthermore, with respect to 16-677B, it clearly states that it is 3 persons. We would agree with the arguments of the other counties, that it's 3 persons. It does not contemplate multiple people in multiple counties. This statute was enacted or came into effect in 1980. This isn't some territorial statute that's just been dragging along. It's been dragging along for a couple of decades, but at any time, the legislature could have amended it. They could have amended it in 2017 when they added the CVR statute in 16-625, but they did not. And with all due respect to Mr. Bennett and his declaration, His declaration indicates that the CVR should be a public record, but that's a policy determination for the legislature to make, not one for the court to make when it's just interpreting the statutes, Your Honor. And certainly, Mr. Bennett, as a state senator-elect, can work to have that changed in the legislature when he takes office. But at the moment, it is not a public record. And so we would disagree with Maricopa County on that it is not a public record. And in fact, there was recently a case in Pima County in front of Judge McGinley on that issue as to whether it is a public record or not. It was a declaratory action from the Santa Cruz County because all of the counties over the last several months have been getting multiple requests from the public for the CVR, and the vast majority of the counties read the statute as it states that it is not a public record. And so Santa Cruz County initiated a declaratory action in Pima County to try and resolve that issue. Judge McGinley just dismissed it because he believed that it was not appropriate for him to make a determination on that, or exercised his discretion, I guess, to dismiss it, but did not make a determination on the issue. Santa Cruz County has filed a motion for reconsideration on that issue in front of Judge McGinley, but again, it hasn't been resolved, but the plain language of the statute is clear. As to the argument that this can't be done because Mr. Jarrett in Maricopa County is not available, Mohave County agrees with Navajo County that under the statute, under 16677, subsection C, it says that the inspection of the ballot shall be made in the presence of the legal custodian of the ballots. The legal custodian of the ballots under 16-624 is the county treasurer because the canvass is complete. It's no longer the elections office. The fact that Mr. Jarrett has to be in court today should not impede the inspectors that the court appoints from moving forward with the inspection today, Your Honor. Thank you.
Your Honor, this is Joe LaRue. I'm sorry. I just need to clarify something for the court. Navajo County and Mohave County are correct that the statute says after the canvass. It doesn't actually specify a time frame other than that. This is 16624, Your Honor, that I'm referencing. It says after the canvass is complete, the ballots are transferred to the custody of the treasurer and they're stored in the vault. That is what the statute says. However, Maricopa County's ballots are under a court-ordered recount right now. And that recount means that the ballots remain in the custody and control of the current custodian, which is Mr. Jarrett, the co-director of the elections department. And I don't want to pick a fight with my fellow counties. I simply want to let the court know why we do believe that Mr. Jarrett is the current custodian. Until that recount is completed and the announcement is made in court, those ballots remain where they are. Thank you, Your Honor.
All right. Mr. Lasota, go ahead.
Thank you, Your Honor. So actually, the case I was thinking of is Babnew v. Linneman. It's 154 Arizona 90, and it is directly on point. In that case, the 15th day was November 29th, and the court heard it on December 1st, and the trial court did, and the Arizona Court of Appeals said that did not deprive the court of jurisdiction. I think Tuesday is the 15th day anyway, but even if it weren't under Babnew v. Linneman, it doesn't matter. So, Your Honor, I know there's sort of a split among the counties about the CVR. We continue to view it as critical, but I know you've seen the declaration from Mr. Bennett. We'd ask for today to have the CVR and get to the actual ballot inspection tomorrow, and then have the hearing on Tuesday. That is our request of this court. And I thank Your Honor for setting this hearing so expeditiously.
Your Honor, Ms. Daneman, again, I hate to raise my voice again, but Babnew does not. Babnew does not stand for that proposition. In that case, the plaintiff didn't, or the defendants did not object to the setting of the hearing, which was contrary to the statute. It wasn't reversible error, but but it does not say that the court can extend the hearing beyond this time period.
All right. Obviously, I don't even have access to Westlaw on my computer. I've been reading the statutes, but I was going to look up the case, and maybe I'll be looking it up in my chambers in a few minutes. I've always found these things difficult, not because they're too intellectually difficult, although sometimes they are for me, but the issue of the timeliness and the speed of which these type of hearings have to be held, which is even more compressed in a post-election process. And I hear the defendant say they waited till the last day to even file it, and kind of ruling that there wasn't even a couple of extra days to reply. And I hear from Pima County, that they got a request to accept service and they just didn't do it. I've read that acceptance of service, which means they don't have to answer for 60 days. That's been used a couple times in other cases that I have to not purposely delay, but delay processing some different types of cases. And they just didn't do it. So they didn't accept service, but the court believes, maybe they should have. This is the type of case where the plaintiffs have rights and they have to be done quickly, and they get the request from them. It is order denying Pima County's motion to dismiss and motion to, which basically says that this court doesn't even have jurisdiction over them for this hearing, that they weren't served in a timely manner. I find that they're here, they are able to participate in this. I read the statute the same way everybody reads the statute, but I guess I don't understand some of the interpretation of the statute. How could a three-person panel, if for example, if I'm ordering today that the Navajo County ballots be inspected, could this three-person panel, I would have to appoint a panel in Navajo County. If I'm ordering Pima County, it's not the same custodian of records on all three of those things, and it wouldn't have to be in that tabulation center in Maricopa County where the bulk and the large amount of the ballots are. I guess I'm confused about why each county wouldn't have their own separate team to inspect that county's ballots. Maybe everybody thinks another $300 bond should be put up. I'm not sure that's true. It's a nominal bond just to make sure that there's some seriousness to this negotiation about this. If you're going, I don't believe 45 people should ever be involved. It's 3 people, 3-person teams inspecting ballots. There's 3 places where ballots need to be inspected. I don't know if that means done after today's hearing in Maricopa County, or done while the hearing's being by someone else that Mr. Jarrett appoints. I don't know, but to me, the ballots need to be inspected, and it isn't a carte blanche. The court does not read in this statute allowing this CRV. And again, I point out that wasn't even requested in the original petition for inspection of ballots. It wasn't something contemplated by the court, at least until reading Mr. Bennett's affidavit attached to the response I received yesterday requesting this hearing. That CRV is an interesting document, but it's just not contemplated being disclosed prior to this, especially in an unredacted form, and the court is not going to allow that to happen at this time. But I do believe the statute contemplates an inspection of the ballots. Now it can't be an inspection of every ballot. I saw Judge Thomason's order where he had them doing a certain amount of ballots. I again don't believe there was a request, and I wrote this down. The list of provisional ballots and the names of those people is not a ballot. That's not something that has to be disclosed under 16377. There has to be an inspection of the ballots by the plaintiffs, and I believe that needs to be done today. I'm going to do my hearing tomorrow. I believe I could technically possibly push it back to Tuesday, but that would be by interpreting, in probably a common sense manner, that we can't do it on Christmas Eve. We're not doing it on Christmas Day. and the court is closed on Boxing Day, a holiday I take, well, others don't. But so I can't do this hearing before the 27th, which is well past the 24th. It would be before the hearing now set to announce the recount that's now set on the 29th. But I believe this hearing should go on tomorrow, and I want inspection of ballots done, and the parties need to agree on that and need to get that done today. And I think it needs to be done in all 3 counties and by 3 different 3-person boards. I don't think that's a poor reading of the statute. I think that's what the statute contemplates. They have to go to where the ballots are, and they have to participate in that process. What I would ask Mr. Lasota is for you to create an order with the person you're named, the person in Maricopa County that's going to do it, that Mohave County has given. We'll put that person's name in it. And then Ms. Jantzen, that person, those 3 people should be the inspectors in Maricopa County. And then you get with Pima County. They'll have an inspector. I've ordered them to give me a name for somebody in Pima County to be the court.
Your Honor, if I may, we've identified someone who's available today to serve in that capacity. That would be Barbara Tellman, who's a member of Pima County's Election Integrity Commission.
All right, I'm going to get all of you to get together and create an order that has all those names on it, and I'll sign it immediately as soon as it gets across my desk. But I want those things to happen today. And then what is the scope of the inspection? Is it, Mr. Lasota, you saw the Thomason order in the Lake case. Was that the type of inspection you contemplate? Are there specific things that you're requesting? I would like to get that addressed before we get off the record today.
Your Honor, our given the time constraints, our major issue is undervotes. So I'll leave it at undervotes. And I have our 3 people. I can send them out to the other parties now, and we could put it in a draft order that hopefully everyone would agree on.
All right, I'm gonna, if you guys can get that done within the next hour or so, I have to leave for a doctor's appointment at noon, but I'll be here all morning, even though I'm still on vacation. All right. So get that to me, and that's what they want to look at, and hopefully Maricopa County can work it out the best way they can. Whether it's, I mean, I'm not saying it should be after hours, but something needs to be worked out that Mr. Jarrett appoints somebody to participate in that process.
Your Honor, Joe LaRue from Maricopa County, we will do our best. We certainly want to comply with this order. We attempted to do this with Mr. Lasota, the exact same inspection that we're going to end up doing today, only in much less time frame and with our key person unavailable. But I will do my best to get it coordinated. And obviously, if we fail, I'll have to explain that to the court.
Yeah, I understand what happened yesterday, and I'd hoped that it had been a little more, would have been a little smoother than that, but it wasn't. And now we're here where we are. So I want that done today, and we'll start our hearing tomorrow. I have scheduled at 9 o'clock. I think there's been some debate. We're going to go at 9 o'clock and just go all day. I'll probably take a lunch break, but other than that, we're going to go all day. So everybody be prepared. And of course, you can appear by Zoom and present your evidence. Hopefully you have it downloaded in our digital evidence system so it can be shared with all viewers. Anything else today, Mr. Lasota?
No, Your Honor.
Anything else, Mr. LaRue?
No, Your Honor. Thank you very much.
Ms. Daneman.
Your Honor, I'll note that the court's order requires exhibits to be submitted to the court today at 4 p.m. as well. We would also request that witnesses be exchanged at the same time in order for us to prepare for the hearing tomorrow. Witness list.
Right. Obviously, yes, the witnesses should be exchanged. I thought that had already happened, but if it hasn't happened by 4 o'clock today, so we know what's going on today. You're going to have to do a streamline just to get it done in one day, so everybody be prepared. I'll be very liberal about admitting evidence, stuff I can consider, so let's be ready to go and move it along quickly so that we can get it done, okay?
Your Honor, if I may, this is Jean Roof with Graham County.
All right.
Given that 12 of the counties are not really involved in this, are we required to appear tomorrow and have our clients appear, or may we be excused?
No, I last week when we first did a hearing, Mr. Moore asked that very question. And I said, no, you don't have to be here unless you're nominal parties. Mr. Moore then became more of a figure in this case, so he's been at this hearing today. But yes, that's the same ruling I made last week, that the nominal counties, including, I don't want to, that aren't part of the inspection and aren't going to be presenting evidence, can in fact not appear, or obviously can watch on. I think there's a YouTube video people can watch us on while we're doing this as well. So you're not required to appear. Thank you.
Thank you, Your Honor.
And Your Honor, can I just request that when Mr. Lasota writes the order, that it be written broad enough to include language that the court's appointed inspector. I suggested Lynn Constable. She had indicated that she may or may not be available, but we have a backup suggestion of Bowen Udall, and and so we'll have to get in touch with each of those two. But I think we need language that we can, maybe
By the time it gets to you, maybe you've got that information. That's what I'm hoping.
Yeah, I hope so too. So, but
maybe make it liberal enough that if one person can't do it, somebody else can.
Yeah.
All right,
Okay.
Let's get it done.
All right. Thank you.
All right. We'll stand at recess, everybody.
Thank you, Your Honor.